if I may. Thank you. Just briefly, and I wanted to direct this to Ms. King. The case of Ms. Castillo was horrific in my mind. But since you have decided to interject it into the proceedings, you mentioned what Judge Dugan did in that case, but you did not come anywhere close to actually reflecting what Judge Dugan said about that case in the transcript. Isn't that correct? Well, let me help you.
Yes.
Let me help you. When this case occurred, I was deeply troubled by it. And as with the case of so many anecdotes, you have to look very deep. So last year, I obtained the transcript, which I have, because I was seriously reviewing my own thinking on the subject. Now, I'm going to ask you this question, and I'm not going to read from the entire transcript because I don't want to discomfort anyone on the panel. But what Judge Dugan said, and I'm only going to read the relevant part, is that this is a very disturbing case. I have substantial difficulty with the testimony of both the petitioner and the defendant in this case. I have substantial difficulty with the petitioner's explanation, and I'm going to omit the facts that he put into the transcript. But members of the committee are welcome to look at it. He concluded, and I have substantial difficulty with the credibility of the petitioner in this case. I have substantial difficulty with the credibility of Mr. Castillo in this case. Now, isn't it a fact that even if the preponderance of evidence standard had been involved in this case, based upon only part of what I have read you, and if you've read the transcript, you know what the rest of it says, the burden of proof would not have been met in this case, even under a preponderance of evidence where the judge found that he had substantial difficulty with the credibility of both parties?
My answer to this would be that I understand exactly what you're referring to.
Right.
And I think that Judge Dugan's comments in this case are more reflective of his lack of understanding about the dynamics of living in a situation when you are an actual hostage of someone else's fury and death threats against your children.
Well, how would the standard of evidence have changed that? Because if
Then
you're saying
then that would have gone to his assessment of credibility.
well, he basically said he had substantial credibility with both. You seem to be suggesting that the problem was Judge Dugan. If that's the problem in your view, which I don't share, then a change in the standard of evidence wouldn't have helped it. But I appreciate you. Let me ask you another question to Ms. Mahoney. Again, because this is a very serious matter, and there is an awful arithmetic to domestic violence, we've been attempting to get, and we think we finally have obtained, you may have a copy of it, I don't know if they provided it to you, an analysis from the Administrative Office of the Courts as to what happens when petitions are filed. And from July 1st, 2009 to December 31st, 2009, just that period, there were 16,553 petitions filed in district and circuit courts, only for that period. The Administrative Office of the Courts concludes that only, and I'm going to ask you the question based on this, only 14% of those petitions were dismissed because the petitioner could not meet the required burden of proof. In other words, only 14%. Are you suggesting that every one of these petitions has to be granted? Is 14%? That strikes me as an extraordinarily high rate of being granted under the clear and convincing standard. So tell me, where is your problem as applied in Maryland?
Do you have the statistics of the temporary orders as well?
I do.
And the fact that a lot of people that apply for the temporary orders are granted, and then when they have to make a decision as to whether to go forward and engage
Well-
with the person that is holding them hostage or terrorizing them, they often opt to not go for the protective order.
Well, that's if I may, I'll give you the exact figures, although your characterization of it is without any empirical data. I will tell you that of those that are denied at the final hearing, 19% occur when the petitioner fails to appear, and 38%, 19% is when the petitioner requests a dismissal, shows up and actually requests a dismissal. 38% is when the petitioner fails to appear. In other words, 57% of those orders that are dismissed at the final protective order stage are because the petitioner either doesn't show up or shows up and requests a dismissal. Now, your characterization of why I think does a gross injustice to what the facts may be. As a practicing attorney, I see lots of reasons why people don't want to send their loved ones out of the country if they're here on a work permit or things like that. But the point is that, and if you're asking about the temporary hearings, where there's virtually, if you can't meet the burden of proof, it's not clear and convincing at a temporary hearing. It just has to be a reasonable basis. And even then, 28% of the petitions that are filed are dismissed at the temporary protective order stage. But of those that go forward, and there are about 11,971 that go forward to the final, as I said to you, only 14% are dismissed because they could not meet the burden of proof. So I'm asking you, what percentage do you think it should be? Do you think everyone should be granted? It's not as if 80% are being denied because of the burden of proof. I guess what I'm saying is I don't see any empirical evidence to support this constant clamor that implies that Maryland, because it does have a different standard of proof, is somehow being less just and less fair to those who come before the courts. Isn't that true?
I have to say that the victims that are denied their protective orders because the judges tell them that they did not meet the standard of proof and then further harm comes of it, that is my evidence.
Well, what evidence do, if I can ask again, in the case, if there was any way to quantify it would be interesting, but I would say this. We had two cases in the last 2 years. The Castillo case was one, and I have taken the time to read this transcript, and I haven't read it all because I don't want to embarrass anyone. But I will tell you that as I did read to you what Judge Dugan, who is a tough judge. You see, he's not someone who's not concerned. Anyone who's ever had a sentencing before him knows how tough he is. And frankly, anyone that knows Judge Dugan knows he is not light on domestic violence or violence of any kind. So I think the characterization of Judge Dugan does a great disservice to him and to the truth. But there was one other case. We had one in Frederick that Lisa Ryan, who's no longer here, from the Washington Post, wrote about. It was a front-page story in the Metro section, and I have that here also, in which it was claimed that the individual, I forgot her name, but I won't go through it, was denied a protective order, and that her husband subsequently shot her and the children. The only problem with that, and that's a horrific thing, but the only problem was that the facts were not there. The actual facts which I have here, because I was interested, was that the petitioner in that case never went to the final protective order stage, dismissed it. And you know what else? She was represented by one of the most prominent attorneys in Montgomery County, Jack Quinn. They had a simultaneous divorce case going on at that case, and I have in here a consent order that at the same time that she dismissed her request for a final protective order, she signed the consent order allowing her husband to have visitation with the children. Now, it's here for you to examine. Problem is that it was projected in the media that the Maryland courts, especially the Frederick courts, had failed this person, when in fact, if there had been a failure, it wasn't the Maryland courts. So when you get to the anecdotes, I think that when you examine them more closely, sometimes you find that the truth is a little bit more complicated than a bumper sticker. So let me ask you one last question about the clear and convincing evidence standard. I'll direct it to you. The Maryland Court of Appeals, in a case that is Volodarsky, which I know some of the proponents are familiar with, tried to explain the function of standards of proof and quoted from the Supreme Court in Addington. And this is what they said. At one end of the spectrum, the low end, is the typical civil case involving a monetary dispute between parties, the outcome of which is of minimal concern to society. In those cases, the plaintiff's burden is a, quote, mere preponderance of the evidence under which the litigants share the risk of error in roughly equal fashion. The intermediate standard of clear, cogent, or convincing evidence is used in cases such as fraud, quasi-criminal wrongdoing, or to protect particularly important individual interests in various civil cases, where the interest at stake is deemed to be more substantial than the mere loss of money. Now, let me ask you about what actually goes on with these orders. Isn't not a fact, Ms. Mahoney, that there is no other, quote, civil order, you've referred to it as a civil proceeding, there is no other civil order where the allegation that you have violated that order can result in your immediate arrest by a police officer, immediate, without a warrant. Isn't that a fact about these orders?
Is it permanent restraining orders as well?
Talking about this order.
No, but I was asking you, can you get arrested without a warrant for a permanent restraining order?
In a divorce case?
Yes.
No. Can't get arrested. You can be held in contempt. You can be held in contempt, but nobody allows you to go out and immediately arrest you. In other words, well, the question is, isn't this a quasi-criminal aspect that is not present in any other civil case?
It's a civil case.
Right. And aren't the interests involved here considerably more than money interests when a man or a woman can be put out of their home, can be denied custody and visitation of their child, as well as involving money interests? I mean, isn't it go way before?
I mean, I think you argue our case very well. For that reason, we need to have the standard of evidence that a pro se person can represent herself
Well,
with a lower standard.
Well, the case that's argued, at least in terms of clear and convincing, is that when those interests are involved, the clear and convincing standard is more appropriate, although legislatures can change it as they have in other places. Thank you.